Good. Okay, by way of introduction, my name is Dr. Chaand Nagpaul. I'm a GP. I've been a GP for more than 3 decades in the same practice in North London. I'm a trustee of the charity Doctors in Distress. I'm the past and the former chair of the British Medical Association, where I did quite a bit of work on medical regulation and where I actually met Viji. I'm also the chair of the BMA Forum for Racial and Ethnic Equality and a board member of the NHS Race and Health Observatory. So I think it'd be worth starting by reminding ourselves why we're here. We're here because every single doctor needs to be registered with the General Medical Council in order to practice as a doctor. But unfortunately, you're all here because you know that this can cause significant distress and in the worst case, doctors taking their own lives due to the regulatory system that they are subject to. We know that those 3 letters, GMC, instill fear and panic amongst doctors. I'm sure all of you here, when you get even a renewal letter from the GMC and you see that those 3 letters on the letterhead, when you open an envelope, instills that sense of panic initially as to what may be beneath the letterhead. Unfortunately, one survey showed that 1 in 3 doctors investigated by the GMC have suicidal thoughts. Just pause and think about that. No regulatory system should be subjecting any individual to that level of distress before they've even had a chance to respond to any allegation. Between 2005 and 13, 28 doctors under GMC procedures, investigations, tragically died by suicide. And between January 18 and December 2020, 5 further doctors under GMC investigation and monitoring took their own lives. Now, in the case of Dr. Suresh, consultant anaesthetist, he took his own life 4 hours after receiving a letter from the GMC. And his widow, Viji, who's organized today's event, and in fact has organized 3 previous events. So this is the 4th event where we're meeting to discuss why the system desperately needs to change to prevent this happening to other doctors and to prevent the level of unfair angst and distress that doctors face by their regulator. And Viji will be saying a few words shortly. In 2022, another doctor, Dr. Michael McPhillips, took his own life. And in the inquest, this is what the coroner said: "I have no hesitation in concluding that the information, the content of communication from the GMC did contribute to Dr. McPhillips' state of mind and therefore contributed to his death." This is what we need to be addressing, is the nature in which doctors are investigated and communicated to. Now, the failings regarding GMC referrals actually are systemic, and they start even before a referral to the GMC. Only 1.4% of complaints made to the GMC actually result in sanction. That means 98% of doctors will have been subject to and I'll describe the harrowing experience of a complaint with the GMC, but actually be innocent. We know that large numbers of these referrals can be avoided. And yet we have a system that weaponizes referrals with no independent scrutiny of which referrals go to the GMC. And there's plenty of evidence that there's actually bias and discrimination in the system. Ethnic minority doctors referred at twice the rate of white colleagues. International medical graduates, 2.5 times the rate of UK graduates. And in fact, one study showed that if you anonymize cases at an employer level, at a trust level, it actually reduces disproportionate referrals, in fact, de facto, proving that discrimination exists against certain ethnic minorities. But it doesn't actually matter, what your ethnic minority is. a referral to GMC is a harrowing experience and often highly unfair. There's no real objectivity when you look at the decision to investigate. How does the GMC decide? They decide through their own panels. There's no external scrutiny. Plenty of anecdotal examples of similar cases having different decisions on whether to proceed or not. Being notified of a complaint. Remember, you're not, most people who know doctors are notified are not guilty. And just the mere fact of being notified results in this cascade of absolute fear, panic, shame, and isolation. The GMC then discloses these complaints to employers, so no one's been found guilty yet. It could even be a vexatious complaint. But the doctor themselves will find themselves often in difficulties getting jobs, being under greater scrutiny, and actually having a lot of suspicion when, in fact, they've not been found guilty. And for many, it threatens their employment and their career right from that word go. The investigation, when you're referred to the GMC, the idea being that it's a neutral act. You're innocent until found guilty. The truth is the total opposite. It's not neutral. It has devastating consequences. And for most doctors, they feel guilty until proven innocent. And if you're an ethnic minority doctor, you can understand why you might feel that just the mere fact of being investigated is a career-ending communication. When you actually look at the investigations themselves, the weights are unacceptable. Dr. Arora, which many of you have heard of, I'll talk about that in a second, waited 2 years, 3 months. And in that 2 years, 3 months, she was living with that anguish and that uncertainty of not knowing what would befall her. Probably feeling the die was stacked up against her. For Dr. Omar Karim, 4 years. It's common for GMC hearings to just be delayed. People on interim orders 6 months after 6 months. When you actually look the way in which doctors are investigated, it's actually inherently an adversarial case-building approach because it is a legal barrister-led process. When you looked at the employment tribunal when Dr. Karim took out an employment tribunal successfully against the GMC's what the tribunal said is that they felt the GMC was looking for material to support their conclusions, looking for case building to win a case, and actually said, these are the words from the tribunal, however trivial and however much they contradicted accounts from those who actually knew about the claimant's conduct and competence, they did that rather than fairly assess the matters presented, because that's what all legal cases do. The barrister's out to win the case. There's not actually parity between the GMC and the doctor. The GMC gets all sorts of information from the trust to build a case. The defendant doesn't quite have the same access to material. And there is multiple jeopardy. That's exactly tragically what happened to Dr. Suresh. And in fact, is the title of the film that Ifat, who will be speaking later, made. And I really hope you'll all be able to view it. Because Dr. Suresh, I think he had multiple jeopardy. There were 7 different authorities that he was facing. And for most doctors, many doctors, a GMC referral is accompanied for many with an internal complaint in their trust, sometimes referral to the NHS England resolution process, and so forth. So there is multiple jeopardy. When you then look at the Medical Practitioner Tribunal Service hearing, this is the GMC hearing, the GMC appoints a barrister. By the very nature of having a barrister, it's an adversarial approach. And you know that barristers are wired, they're hardwired to win cases. They're not there to look at the careful pursuit of truth. You're not going to see a barrister halfway during a court case saying, well, actually, I withdraw the case because I really believe what the defendant's saying. That's not what they do. When you actually look at the case of Dr. Manjula Arora, who was suspended for 1 month after two and a half years or so waiting for the hearing, and she was actually suspended for a month for dishonestly claiming that a laptop she was told she would be receiving, she felt she'd been promised. So the word promised is what landed her into difficulty. But when you actually look at the tribunal itself hearing, she suffered grueling cross-examination because of this barrister-led process. She was even accused of bringing the profession into disrepute for this one remark. Just think about it. It's mad. It doesn't even make sense. The GMC agreed she was a person of good character, but suspended her to send a message to the public and profession. I wonder whether the public and profession have actually, in any way, increased their confidence in the GMC by actually finding a doctor guilty of using a word and then suspending her for a month, not being able to see patients. So there's some real questions about the process regarding MPTS of maintaining public confidence. And remember that 70% of doctors who then end up in hearings are found not guilty. So in summary, I strongly believe that the whole referral process, from before referral to the GMC, and each stage of the GMC process, from assessing whether a case is investigated, the investigation process itself, the hearing needs to be radically reformed. And the only way that can be done, in my view, is to have an independent root and branch review of reform of the GMC. It's an article that I wrote in May 2022. It's as relevant, I believe, today, because we haven't seen that happen. I've spoken to the GMC's chief executive and felt it's in the GMC's interest to actually have an independent review, because that would actually give doctors the confidence that by having a review and having reform, we can have a regulatory system that rightly protects the public, patients, but also is proportionate, is fair, and one that is compassionate to doctors who work in the health service. So I'll pause there, and we'll now go on to the next part of the meeting. And it's, in fact, your program has Ifat and Sasha, but I'm actually going to invite Viji to say a few words, because today's conference and the 3 previous conferences are really down to her, and her determination, laudable determination, to channel her personal grief and loss into change that will make a difference for doctors and also, of course, for patients as well. So Viji, over to you.
Thanks, Chaand. Good afternoon, everybody, and thanks very much for joining in spite of your Sunday personal time. In spite of your Sunday personal time, you have all taken time to join us, and welcome everyone. So as Chaand has mentioned, this journey for me has started mainly due to my personal experience and my personal loss. One thing I could do here is I can channelize into a positive change, or I can sit in the corner with my family and grieve forever. I opted the former. So how do I channel this into a positive energy? And I'm not a medic, and I don't know what has happened. I don't know the terminology called GMC 7 years before, until when I know that a letter killed my husband. And that is where I started thinking, what exactly is this? It took lots of time to understand, as a non-medic, when everything, or non-medic's wife, when everything goes well and fine and shiny and happy, no one realizes this kind of dangers that a medical doctor is put under, and whenever needed, it is likely to shoot up. And this hit me. I learned my lesson in a very, very hard way. And first thing I felt was there is absolutely no awareness among the medical professionals and their immediate family about the dangers of their professional career. And one of the first thing is, when something of professional distress situation scenarios happens, first thing that happens in any family or in any doctor is they shut down. They completely shut down their emotions, their communication, their friends, their families, their relatives, whatever, whoever it is, and the colleagues as well. And they go down into their own mode of personal grief and reflection. And they absolutely sit down in a corner without knowing how to come out of this or how to face this. And this is the kind of awareness. One thing I was determined is, I know I can't change anything. I know I have to face this, but only one thing I could do here is to create some awareness. How do I create the awareness? It is a process of campaigning. How do I do it? I didn't know. And I need to thank all the organizations such as BAPIO, BMA, and many other organizations who had helped me in this journey. So we started with a petition against the GMC about what has happened in 2020, and it got around 30,000 signatures. And we went through, there are two things. One is, this is my personal desire as a campaigner. And the second thing is, I need to go through quite a lot of strenuous legal process. Even though this happened, I have to go into the coroner's office, coroner's court, and many other courts, including currently I am in the High Court for various other, for facing this particular journey and to get justice for my husband's loss. So I'm now facing, in this 7 years, I've seen all kind of courts and legal processes. And also in the other side of it, I also want to do a campaign and create awareness. So how do we create? So these two are two parallel orthogonal journeys as it stands, and it has to go in parallel to each other. And the third journey is going to be, I have a family and life, as well as a single mother, you have lots more responsibilities. So first thing is creating awareness. It's a process, it's a journey. We are going to do it separately. And what is the motive for this journey of creating awareness is to bring in a change and the reform as it stands. So how do we do that? So we need to understand what is the problem in this particular scenario when a doctor goes through this situation. So how do we do this? In parallel, when this was happening, we had another process where we had a legal journey where we go through a dispute resolution process with the GMC and other parties involved in this journey. So with the GMC alone, what we did was we had presented approximately 21 points where the GMC need to make changes to its own policies, processes, and there is also a potential legislative changes that could come. However, that didn't go well. However, our journey continued with this campaign and the awareness, this continued. And this 21 points is categorized into three different areas. One is around protection of doctors' life and livelihood. The second one here is around inappropriate investigations that is faced by the doctors. And the third aspect is around discriminatory processes. So these are the three categories we found where all the processes are failing and trying to hit the doctor in various directions as it stands. So in these processes, these three categories that we had created, we coined it as doctors' rights. And after that, we decided to call it as a doctor's charter of rights. So when we look at doctor's charter, currently when we see this, there are charter for patients protection and the patient's right. However, for doctors' protection and the doctors' rights, where are the policies and the legislations? That is where we need to look into it. And that is what we tried to, we started thinking around the doctor's charter of rights. So these three rights, doctor's life and livelihood, inappropriate investigations against the doctors, and the third one is the discrimination faced by the doctors. So we convene every year a free conference, and this is to disseminate this information. And we want to listen to doctors, to hear the doctor's voice. That is important. And we named it as Voice of Doctors. And today, And we conducted every year, we conduct lots of, we conducted surveys, we start analysis, and we start reflecting ourselves. And it's a very long journey. It's a process of 6 years. 4 years we are conducting this conference, and this year we are analyzing the results, and that is what we are analyzing the results and presenting it, and a lot more to come. And that is what we are here to disseminate our information and also gather some knowledge from you all. If you want to share something, we are listening here. And this is our journey. And thanks very much again. And I'm passing it to Chaand. Thank you.
Thank you, Viji. Thank you very much. And the next part of the meeting today is actually to hear about the survey that was conducted by Viji and team, and to actually present that and the voice of doctors sort of messaging from that survey. I'd like to invite two people. First, Dr. Ifat Ataullah. Now, Ifat, some of you, well, those of you who attended last year will know, has produced and directed the most moving movie, a documentary movie about the circumstances that led to Dr. Suresh taking his own life. And she's also, in 2020, published a paper called Maintaining High Professional Standards, Morally, Ethically, and Fairly, which was actually based upon her personal experience herself 8 years earlier, when she underwent unfair trust investigation for alleged unprofessional conduct. And she teaches doctors on NHS disciplinary matters, and she's been supporting and working with Viji since 2019. But I'd really plug the movie Multiple Jeopardy. It is, maybe put the link in, if it's onto the chat, because I strongly recommend you watch it. It's highly moving and insightful and powerful. The other person today for the next session is Sasha Burns, who's worked in the NHS for over 25 years and for over 10 years as a consultant until she lost her job in very unjust circumstances. She has fought battles with the MHPS, employment tribunals, and also GMC battles. She's now thriving in a new career, working for the HCSA, a doctors' union, fighting for justice and equity for doctors. And I'd like to invite both of them, Sasha and Ifat, to present the next part of the program.
Hi, everybody. I'm just going to share a presentation with you. Just give me a moment. Do you want to say hello, Sasha?
Good afternoon, everyone, and thank you for coming this afternoon. Spending your time, as Viji was saying, your own personal time, it really counts a lot that everybody's here. And I hope you can all learn from each other and contribute. And we'll get to have a good old discussion at the end of the session. I think we're ready to share, Viji. Ifat.
Hi, everyone. Firstly, I'd like to thank Viji. After Suresh's death, many doctors spoke to her of their own experiences, and she really did listen. This survey is very much her brainchild and born to give those doctors a voice. Secondly, I'd like to thank Raj Chaudhary. He's a very experienced medical legal advisor, and his expertise in both the GMC and NHS employment systems, his work with clients who face professional distress, was invaluable in the creation of this survey. Sasha and I are simply presenting the results today. I'm just going to talk about the why. Let's dive straight in. Person 6 in the freeform section wrote this: I could not give you my NHS net address because I'm presently suspended from the NHS practice for 6 months as a result of what was an inappropriate referral of simple harassment. Lies from the referrer to the police, the GMC, and the tribunal about me, and a refusal by the GMC to read or listen to the evidence that would have exonerated me. The referral was unrelated to my 42 years of an unblemished practice as a doctor. It took 5 years to deal with and had been discounted by the police, who offered no evidence. My accuser has a history of serious mental health issues and of previous unfounded allegations, but she refused to allow access to her own medical records in reference to her previous behaviours. At multiple levels, I feel entirely let down by the whole process. Despite apologising for multiple mistakes, the GMC felt it appropriate to suspend me, even though my accuser admitted her lies publicly. I have suffered grievously, as have my family, friends, patients, and students, along with those who we supported financially in Africa and who depend on us. I greatly appreciate the opportunity to explain and express my horror at the behaviour of the GMC and the NPTS to you in greater detail, and offer my unconditional support for your attempts to reform the system. Over to you, Sasha.
So the survey was born. At an annual conference, doctors were invited to complete the survey, disseminate it thoroughly to colleagues on social media and so on. It was shared on a BMA newsletter. This all happened in 2022. The slides show the information that was collected, the date that it was done, and the number of questions. So I think it's worth explaining what happens when a doctor is referred to the GMC, just so that everyone who's listening understands where we're coming from. And then the issues that arise from a referral can be more easily understood, I think. So essentially, a referral regarding a doctor can be made to the GMC by anyone at any time. Any member of the general public, another doctor, the employer. The referrals may be entirely malicious or entirely justified. Referrals made by the employer are far more likely to be taken forward, and sanctions are more likely to be put in place. The investigation process can take years and often does. If the allegations are thought to be serious enough, then the doctor may be asked to attend an interim order tribunal. This is before any investigation has taken place, immediately after the referral has been made, where they may have their practice restricted. There are issues regarding the standard of proof, which was changed in 2007, and whether when the police are involved, a doctor should have to go through a police investigation and then a GMC investigation as well. If the GMC's investigation finds that the doctor's case should go forward to a tribunal, the Medical Practitioners Tribunal Service, the MPTS, the doctor, plus or minus lawyers, will face the GMC's lawyers, and the panel decides the doctor's fate. So what are the issues that arise? Well, first of all, the actual appropriateness of the referrals, the timeliness of the process, the issue regarding the standard of proof, criminal versus civil, and should the GMC continue with investigations once the police have decided that no further action should be taken, or if the jury find a doctor not guilty. What about, is there an ability to appeal an interim order that has been placed unfairly? And what happens regarding income? Doctors may suffer due to being suspended from their practice. They may need compensation. They're also de-skilled. And what about addressing issues of discrimination? Over to you, Ifat.
Thank you, Sasha. You'll notice it's question 6. That's because we've grouped the questions in topic areas. The question that was asked was, do you think an independent scrutinising body should check the appropriateness of each GMC referral? The answer was an overwhelming yes. Person 4 commented, I feel there should be a separation of the body that accepts complaints and rules on it, and the body that is involved in the investigation of the doctor in question. Both should be independent of each other. Both processes should be transparent and subject to challenge, which would be inexpensive and quick. So the next question was, do you think referrals should be anonymised prior to scrutiny? And the answer was overwhelmingly in agreement, 90%. They clearly felt that anonymisation might make the process fairer. Relevant comment, person 1 said, that all complaints about doctors must go to the GMC in an anonymised form, making sure not to include subtle clues about their place of qualification, religion, ethnicity, etc. The next question was, do you think that GMC should be forbidden from circulating unproven complaints, referrals about sensitive issues, such as sexual assault, to employers or contracting bodies? I thought this was an interesting and important question. We can see that around 77% of respondents agreed, but not 90% as the other slides. It tells me that respondents are thinking carefully about the question and recognize that there are predators amongst doctors, and that it may be appropriate to share some information with some agencies, but it should be tailored and handled very carefully to individual cases. But we have an example to share in Dr. Suresh's case. This is a letter he got from the GMC by email, and it looks fairly straightforward, if worrying. They say, the next step for me is to write to organisations for which you're employed or provide services, as is required under the Medical Act 1983. This is to inform them of the investigation and for them to send us information which will help us with the investigation, either about concerns that have been raised or your practice as a whole. I may share information about the concerns with them when necessary to do so. It all looks sort of fairly standard, and I expect it's what standardly doctors get and what happens with an interim orders tribunal. And it looks harmless, but Suresh was alone at home. He did not know that the police had referred him to the GMC 2 weeks earlier. He had not been charged with any crime. The fear of what was to come and the stress of the previous few weeks was so great that within hours he took his own life. Person 1 said, information about the doctors wherein their reputation will come to stake must not be revealed to any other body or organisation unless there is a very strong evidence of risk to the public. Thank you, Sasha.
Thank you, Ifat. So the next couple of questions are about timeliness. So the question is, should there be a specific law on the timeliness of the GMC investigation of the doctor's complaint? And the breach of time limits should be enforced through effective compensatory measures. So obviously timeliness is an issue. If a doctor has been suspended, they become de-skilled, investigations last for years, and it could be that eventually there's no case to answer. So is there any way that a doctor can claim compensation? And it should, and when this question was posed, 98% of those that answered approved that there should be a way, that there should be some form of enforcement on time limits, and if they're breached, there should be compensation. Person 2 and person 3 commented that prolonged hearings and suspensions with unrealistic goals and interim orders should be stopped, and all dependents should be financially supported until an investigation is complete. Question 5 was, do you think a mechanism to accelerate the process of investigation and evidence collection should be undertaken in cases where the doctor's livelihood is under pressure due to exclusion from work? So very specifically for those who do a lot of private practice, if you're excluded from work, then you will simply lose your income. I would emphasize that if you're still employed by the NHS, then your payment would normally continue while the investigation is carried out. But obviously there's an awful lot of distress that comes from being investigated by the GMC, and overall this should be accelerated, and there should be a process, we think, where those who are particularly suffering, that there should be a way that you can actually accelerate the process. And in this case, 98% of those that responded agreed. Question 8. 8 and 12, the next two questions are around the standard of proof and the police involvement. So question 8, if the court or police present an outcome that the doctor is not guilty, do you think the GMC should have the power to carry out their own investigation into the same issues because they can find the doctor guilty, applying a lower standard of proof, the civil standards? So essentially, The issue is that if the police don't take a case forward, no further action, NFA, then they have applied the same standard as the civil standard used by the GMC. So therefore, it would seem unjust that the GMC would run another investigation. If the police, however, take the case forward to court, so thus the suspicion satisfies the civil standard of proof, but the doctor is then acquitted by the jury, the standard in the court being that of the criminal standard beyond reasonable doubt, then the GMC could arguably take the case forward because they have a lower standard of proof. If the police take the case to court and the jury find the doctor guilty, the standard being the criminal standard of beyond reasonable doubt, then the GMC probably should run their own investigation. However, it is interesting to note that in that situation, the GMC may not act in the same way as the jury. I'm just considering the Bawa-Garba case as an example. So when this question was posed, 48% of those that responded disagreed that the GMC should have the power to carry out their own investigation, but the answers were more widespread than in previous questions, and that may reflect the complexity really of the issue and the varying situations that may occur. Question 12 is around the standard of proof. So until 2008, the GMC had to prove an allegation against a doctor to the level of beyond reasonable doubt, the criminal standard. In 2008, they changed this to the lower standard of on the balance of probability, which is the civil standard. Should the burden of proof for the GMC in fitness to practice hearing revert back to the criminal standard of beyond reasonable doubt? So essentially, there was a wave of changes following the Shipman event. Dame Janet Smith's Shipman Inquiry Report number 5 recommended what should happen in the future, how doctors should be regulated in the future, and so on. The main issue for me is that innocent doctors will be caught up in what feels like the trawler net that is the civil standard of proof. So many more people can be caught up in a balance of probability situation versus a beyond reasonable doubt. And that for me does seem to be a problem. So regarding the answer of the question, in this situation, over 86% of respondents agreed that the standard of proof should change back to beyond reasonable doubt. And then what about interim order tribunals and interim orders that are placed on doctors? So question 13, the GMC can ask a doctor to appear before an interim orders tribunal without undertaking any investigation of its own. IOT can order a suspension or registration or impose conditions simply based on the gravity of the allegation, even if there is little or no evidence to substantiate it. IOT often makes these interim orders on the grounds of maintenance and promotion of public confidence in the medical profession. At present, interim orders may only be appealed in the High Court, which may be very expensive and difficult for a doctor to do. Should there be an appellate tribunal to review interim orders from the IOT? So, there certainly is research that shows that over 2/3 of the cases where doctors have had interim orders placed, the actual interim order is more restrictive than the eventual sanction placed on the doctor by the GMC. So there is therefore huge damage done to the doctor, which in the end is not valid. And when this question was posed, over 92% of respondents agreed that there should be a way, an easier way, to appeal an interim order that seems to be unfair. Over to you, Ifat.
The next 3 questions are about protection for doctors and compensation. The first one was, should there be statutory protection of doctors' right to practice their profession? And where that right is unfairly restricted, should there be a simple and workable mechanism for a doctor to claim compensation against the GMC for loss of earnings and distress? Overwhelmingly, 95% of doctors agreed, and it speaks to the processes that impact on the livelihood of doctors and the long-term effect they can have. The next question was, should there be scrutiny of the GMC undertaken by an independent committee consisting of doctors when a doctor under GMC investigation suffers harm. In other words, what is the comeback on the GMC if a doctor suffers harm as a result of the investigation? Simply put, the current status is that the GMC can screw the doctor over and there is no comeback. That needs to change, right? Relevant comments. There should be recourse, remedy, sanctions for vexatious allegations, abuse of whistleblower privilege, regulation of managers, middle managers who abuse their position of trust. I appreciate current efforts by the GMC to try and improve. It has been slow and difficult, resulting in grave miscarriages of justice, delays and deaths. However, protecting everyone, including doctors, should be the remit, along with the principle of innocent until proven otherwise. Vicarious, I think the person meant maybe symbiotic, relationship with the legal profession, prolonged hearings, appeals should be stopped. Value for money, pursuing, driving doctors to death should be stopped. Suicide is the tip of the iceberg. Natural causes of death, including strokes, MIs, driving accidents, may be due to the stress of unfair, prolonged investigations and sanctions. It does seem, these are interesting comments and they speak to kind of hidden agendas in the system that need to be uncovered and brought to the fore. It seems that there's a symbiotic relationship between the GMC and the legal profession, and it has become an industry within an industry, and the people who always win will be the lawyers, especially with protracted cases. So meanwhile, the doctors suffer. Next slide, please. The last question was, should there be a dedicated tribunal to hear the complaints of discrimination against the GMC? And overwhelmingly, 97% of doctors agreed. That doesn't really need any comment, and it's the end of the survey results. I'm just going to hand over to Sasha to wrap up.
Yeah, thank you, Ifat. I think the survey was fantastic, and I think there's been lots of really interesting feedback. It was interesting to see how convincing the respondents were for many of the questions. So a lot of people agreed with a lot of what was said, which was good to see. Really, that everyone's singing from the same hymn sheet. I think that these final comments that we've got are very telling, and so true, that we should presume innocence, that the GMC, we need a GMC, doctors need to be regulated, but it needs to be done so fairly. Where's the safeguarding of the doctors that have these malicious allegations made against them? What about that? And that there should be fundamental changes in the disciplinary processes, including the MHPS, because it is misused, especially using the conduct trump card. And I couldn't agree with that more. So we're going to have questions at the end of the conference, and we can certainly answer questions regarding the survey at that time. Thank you very much.
Thank you, Ifat and Sasha. We will, of course, have questions at the end. We'll move on to the next part of today's agenda, which is actually a talk, I think a very personal talk, from what I understand, from Peter Duffy. Peter is an ex-consultant urological surgeon, and he is a whistleblower known to many of us in social media. In fact, Peter unfortunately had to spend 6 months of his career living and working on the Isle of Man after his whistleblowing in 2015. He has suffered, as I read this, Peter, 7 reportings to the GMC, 2 reportings to the police, and 3 major GMC investigations into his fitness to practice. He subsequently resigned and erased himself from the medical profession to prevent further malicious reportings. Peter, over to you.
Thank you very much, Chand, and thank you, Viji. Can you hear me all right? Can you hear me? Great, that's good. So thank you both for your leadership on this and for your courage, Viji. Yeah, I'm Peter Duffy. I'm 62. I was a consultant urological surgeon. I think I've got about 15 minutes to take you through my experiences. So I was going to spend about 5 minutes on the whistleblowing background, 5 minutes on the GMC investigations, and then the final 5 minutes or so on the last investigation, just simply because it turned out to be so sinister. So I was appointed as a consultant surgeon back in 2000, but it was about 2015 in the end when I finally sort of broke ranks and went to the Care Quality Commission. And this was over some very broad concerns that I had over patient safety, but also the very specific concern over a patient death, a gentleman called Peter Reed, who died from what I felt was negligently treated sepsis. And this was compounded by the fact that we'd had an act of disobedience to the coroner in the subsequent inquest as well. So it was clear there was a cover-up going on. And having gone to the CQC, rather than them investigating the department as I'd asked for, they instead went to the medical director with my concerns, which of course straight away revealed there was a whistleblower in the department. And by less than a year later, I was unemployed, despite the fact that I'd actually been made the Trust's Doctor of the Year in the meantime. So trusts have a specific way of managing you out of your job. And we haven't really time to go into the details of that, but it's all about things like pay cuts and demotion, disciplinary action, and so on and so on. And it ended with a threat to impose a retrospective pay cut on me. This was summer of 2016, and of course you then have to leave before that's imposed. So I spent the rest of 2016 unemployed. I then finally, as Chaand said, I got a job on the Isle of Man, and in fact I was there for 6.5 years. So I had to leave my family in Lancaster and move and start renting a flat there. So I stayed there for 6.5 years. The whole thing went to an employment tribunal. I did get the BMA support there, which was great, thank you. But I was absolutely appalled by the standards of justice there, and it probably isn't that different from an MPTS procedure. So evidence was withheld or went missing. The witnesses I'd lined up were told that the department might be dissolved if the case went badly, and so every one of my Morecambe Bay witnesses from my old employer dropped out. The most important witness refused to sign the witness statement that was written out for him by the Trust. And having written his own, was then told he would not be appearing and the witness statement wouldn't be provided. And then I was hit with what is called a costs threat or without prejudice letter just a few days beforehand, threatening me with £108,000 of costs if I didn't drop my case, basically shut everything up and agree to a COT3, which is a kind of gag. So although we did in the end win the case, I got 102,000 for calculated costs of around £250,000, so not the best of days for UK justice. So that's the background to my whistleblowing, and I was so angry about all this. I felt such a sense of outrage that I actually went and I wrote a book about it. So that was published in the summer of 2019. Led in the end to questions in the House of Commons and to MPs' letters and so on. And that in turn then led to an NHS England funded and directed investigation using private investigators. So we'll come back to that towards the end. So that's the sort of background to the whistleblowing. In terms of where this brings in the GMC, I mean, my whistleblowing went back many, many years to the early 2000s, and I was first reported in, I think it was about 2010, 2011. That investigation went on for about 18 months. It was closed in the end with no case to answer. And when I insisted on speaking to the investigating officer, who would only speak to me by phone, I was told that I'd actually been reported by somebody from within my own department. So it seemed pretty clearly to be revenge for my whistleblowing. And for anybody who's interested in the subject, I would recommend you have a read of the 2015 Hooper report, which is freely available online. If you just Google 2015 GMC Hooper reports, you'll find it. So the GMC know these are standard tactics. Unknown to me, I was then reported another 4 times. I only found out about that when we asked for full disclosure prior to the employment tribunal. So there's a lesson there in that if things go quiet, it doesn't necessarily mean that there aren't things going on in the background that you're unaware of. I was then, after I'd published the book, reported again, I think this was now autumn of 2019. That investigation, well, it ran to 500 pages of evidence and allegations against me. The investigation lasted around 2 years, again was dismissed with no case to answer. But that was really quite nasty, all sorts of allegations ranging from operating whilst drunk to intravenous drug abuse to fraud to clinical negligence and so on and so on and so on. In the meantime as well, I'd also been reported twice to the police. Luckily, both of those went nowhere. So that was the 6th reporting. That, I think, was closed in about 2021-22 with no case to answer. And that then leads us on to the final investigation. So this is where it really gets very, very sinister, almost Kafkaesque or Orwellian in the way things developed. So in early 2020, the NHS England had brought in these private investigators, not, I think, unlike the Post Office using private investigators to pursue the postmasters. And I was warned from a number of sources that this was unlikely to end well for me. And one particular tip-off, which was anonymous but clearly came from somebody pretty senior in the trust, warned me that there was tampering with evidence going on and a desire to see me in prison for the whistleblowing that I'd done, which had reflected so badly on the trust. And then within a few months of this tip-off that there was tampering with evidence going on, I was summoned to an urgent Teams meeting with the NHS investigators. So at the time I was stuck on the Isle of Man. We were in lockdown, so it was a Teams meeting. And I had 2 emails sprung on me. So I had no legal representation at the time. I hadn't suspected anything like this was going to happen, and I hadn't been warned. And these emails very much rewrote the death of the gentleman, Peter Reid, who had died of poorly managed sepsis way back in 2015. These emails, it was claimed, had been written by me in 2014, at the end of 2014, and very much laid me wide open to allegations ranging anything from sort of medical manslaughter to contempt of court and perjury and so on. My immediate reaction, of course, was that these were fakes. But what then happened was, over a couple of meetings and various telephone calls, I was worn down into believing that these actually might well be genuine, that maybe I really had caused Peter Reid's death through negligence and neglect. And I was repeatedly told that there was no evidence, nothing in the records that might suggest that these had been backdated and introduced into the records just very recently. And so in the end, not only did I, on the record, confess that I appeared to have behaved in a negligent fashion, I even actually phoned up the bereaved family, thinking that I owed them a duty of candour, and told them that I appeared to be guilty for the death of their father, of medical manslaughter potentially, and that I felt I should plead guilty to any charges. In the meantime, the emails were passed on by the trust, I believe, to the General Medical Council, who opened another inquiry, this being my 7th. And for a good number of weeks, I was most certainly a huge suicide risk. The NHS team were well aware of this. They even tipped off the Isle of Man authorities, presumably, maybe I'm being cynical here, but to cover themselves in case I really did take my own life, so that it could be then blamed on the Manx authorities for not putting me in a place of safety. And so for quite a while, I resigned myself to the fact that I was potentially going to go to prison. And of course, the huge shock was about 3 or 4 weeks later when the bereaved family called me back. I thought they were going to tell me that they were taking me to court. They actually told me, did I realise that they'd asked for all the trust's archives and servers to be searched for all details of emails mentioning their father, Peter Reid, back in 2018 after the Employment Tribunal publicity, and these emails, which had popped up in 2020, dated 2014, of course, they weren't there in 2018. And then when I went back and spent several months checking through the records, it became very clear that not only had these emails, these 2014 emails, not existed in 2018, they'd also not been there when the records had been searched earlier on the orders of the tribunal judge, and also in 2016, 2017. So it was clear that not only did I appear to have been stitched up here, but that I'd been fed completely misleading information that had extracted from me a confession of guilt when the exact opposite conclusion should have been reached. So I'll wrap things up fairly quickly now, but that GMC investigation ran on till the summer of 2023, so last summer. And although I passed the information which seemed to prove backdating back to both the private investigators and the NHS, nobody withdrew the allegations to the GMC. There was no sort of recognition of this or investigation of how this evidence suddenly appeared in the records. And the GMC, despite finding their own evidence suggesting backdating, just simply closed the case down in summer of 2023 and said no case to answer. By that point, I had cracked. I'd broken under the pressure. I told the Isle of Man authorities in early 2023 that I just didn't feel safe to work any longer, that I was getting distracted and I was a hazard to myself and to the patients. And having made that decision that I should stop working, I was then advised legally that not only should I resign and leave the job, but I should erase myself from the register, because as we've heard, there is this ridiculous multiple jeopardy situation where you can just carry on being repeatedly reported until whoever or whichever organisation is reporting you gets the result that they want. So I erased myself from the medical register last summer, and essentially I don't work anymore. I've been forced into very, very premature retirement. That's my story. Hopefully I've got through that reasonably promptly, and I'm happy to take any questions, or we can put them off to the end.
Thank you very much, Peter. And I'm sure everyone who's heard your story is feeling both shock and this huge sense of injustice. And I'm so sorry for everything you've been through. And I know that you have put a lot of your experience to promote the need for change. And we will be happy, of course, we'll want to be discussing more with you in the questions and answers, which will be at the end of the last item of today. But thank you again, Peter. I'm now going to invite my colleague, Phil Banfield, just so that everyone's clear. I'm not here today representing the BMA. I'm chairing this meeting independently as someone who knows Viji, but I, of course, worked with her when I was former BMA chair. But Phil is going to be now, who's the chair of council, going to be giving us an account of the BMA's role, the current work it's doing to support medics in professional distress. Phil, over to you. Phil, we can't hear you. Phil, we can't, well, I can't hear you. I don't know if
right. I couldn't find the button for a minute.
Okay.
What have you got on your screen at the moment?
I've got the British Medical Association is also.
Right. Okay. Let me go back one. Okay. So thank you very much, and thank you very much for sharing your horrendous stories. I'm always very keen to do this meeting because the BMA needs to understand what is actually going on in real life. So even though I'm in France at the moment, without perfect IT, we'll try and get on and give a brief overview of what the BMA's role to support medics is. I've watched the chat bar, and you will you don't need me to tell you that we are not perfect and we don't get it right. And I kind of want to explore part of why that is the case as well, just to extend the conversation. So, as you know, we're not just a professional association, we're a trades union. But Chaand before me and we've tried to continue it. So the aim is to improve terms and conditions for all doctors, not the few, but for everyone, and that's by standing with our members. And I get that from some of the stories in the side that doesn't always feel the case, and that's about meeting the needs of the members when the BMA can seem very remote to you. What the BMA is not is it's not a medical defence organisation, and that throws up some real disparities when the issue at work might be to do with professional competence, and it is possible for the MDO and the BMA then to find a situation in which, although we do work together, a particular member's case can fall between the cracks, and there have been a number of examples of that over recent years. But when we're talking about what is the need, the BMA has been really quite good about addressing things nationally. You will be aware that the latest industrial action from the last 2 years has secured an additional £1.5 billion for doctors across the UK that wouldn't have been given to doctors otherwise. And you will have seen Chaand's leadership during the COVID inquiry and the recognition of the disproportionate effect on Black and minority ethnic doctors that I'm able now to put out into the public domain as part of the COVID inquiry. But actually there is the bit, and this is coming up, I think, as part of this theme, about actually what is going on in the workplace. The BMA does get it right sometimes. So this is in the last couple of weeks. If there is a case, if there is a legal basis, then actually the BMA is quite good at pursuing cases and winning. So here is a case of individual racial discrimination, clearly being victimized in the workplace, clearly having an investigation that was not aimed at getting all the information out that would exonerate the claimant. And the consequence to that is over £500,000, because no one actually wins in that situation, because quite often a career is ruined. Now, we have a diverse workforce, and although we would want it to be an inclusive workforce, unfortunately, exclusion and feeling outside of what's going on is all too common. Now, you'll be familiar with ethnic diversity issues, but there's an enormous amount of contradiction, and the issues over misogyny and sexual harassment in the workplace, and especially if you go across intersections of different groups. But it's also about whether you are relatively new to medicine or whether you are established, whether you are trying to get your training or provide service. It's also a variation in our attitudes to safety, and I will talk about that a little bit further on. So you can find yourself very individually, easily set up in a workplace that should be inclusive, and finding yourself on the outside of something. Now, the BMA does have policy about the GMC. It would. I'd be delighted if someone could give me a legal way that we could pressurize the GMC by withholding our subs, for example, to the GMC. But there isn't actually a legal way of us doing that. But we have been pressing the GMC for change, and I hope that you have seen that we've had some quite vociferous spats in the public about the GMC, and I'll talk about a few of those later on. So we are continuing to call for clear processes in the workplace and to campaign to lobby the GMC and employers. Remember, there are two aspects to this. The referral to the GMC comes from the employer. That could and should be anonymised. Unfortunately, the evidence that suggested that that was beneficial, no one can actually find the evidence where that's been presented. But there's reason to believe that that would be helpful. And that's separate to that the GMC could also then take the referral and anonymise it in its processes throughout that. So we do support whistleblowers. I would really want us to do more about whistleblowing. The issue is about the linking of the whistleblowing, the protected disclosure, to any detriment. So, if you like, the traditional way that the BMA offers employment advice is you phone the BMA up and say, I think I've got this issue in work. I think it's whistleblowing, and the BMA says, "Are you sure? Right, come back to us when you're sure that it's a protected disclosure." At that point, they come back and say, "Well, I've made the protected disclosure. Have you had a detriment?" Because it's until you have a detriment, you don't have a case. And that's really coming in after the horse has bolted. And what I'm trying to do is I'm trying to get the BMA into the workplace before either of those events have happened, to be with doctors as they are raising concerns. Now, we do sometimes, there is a link that you can pursue, and you may be familiar with Rosalind Ranson, who was the previous chief medical officer in the Isle of Man, who basically, as far as I could see, said to the Isle of Man government, "Do you know what? If you lock down early during the COVID pandemic, you are going to save lives of people on the island." And not only was she ignored, but they then actively went out to wreck her career. And it's just a recurring thing. Both Chand and I have listened to case after case after case of the sinister way in which people dismantle reputations of doctors genuinely trying to raise concerns. It's an awful place to be. And it's very easy for the situation in the NHS to throw up patient safety issues because it's so under-resourced. And we are working in situations where mistakes happen. They happen very easily. But we have not shifted that culture of blame or racism or bullying or sexism. They are endemic in our workplace, in the NHS, and it remains a challenge for all of us to try to change that. And of course, as Chand pointed out earlier, it's just a horrible statistic. It's awful. That one doctor on average takes their life every 3 weeks or so. And the GMC investigation and what the GMC can do to you, and the one-sided nature of it, is something that we do need to try to shift and manifestly change. So what happens, if you are in, got a problem in, well, I thought I'd put it into the BMA. What happens if you go onto the BMA front page? Didn't have anything about wanting to help me. It talked about the GP in England taking collective action. So I thought I'd keep going a bit more. And it was offering me in the next page when I typed in help. No, that didn't really help me. It took me to somewhere about doctors protecting doctors. Had to come back out. into advice and support, into wellbeing support services, and then I got to something that might have given me a telephone number to phone to get the issue. Now that's too difficult, right? That's too long to, if I have a crisis at that particular time, I'm not responding as the trade union and as someone that's purporting to offer help to the needs of that person at that time. I'm an obstetrician in North Wales, and with a highly deprived population, has a very high incidence of postnatal depression, high suicide risk, and we advocate that every pregnant woman has a personal safety plan, because you never know when you're going to need it. And in some ways, these conversations in the situations that we find ourselves in as practicing doctors are the sort of things that perhaps we should be talking to each other about in creating our own mental health plan. So what about, what do I do if I'm really on the edge? Do I know what to do? Is this something that I've thought about how to get help? The BMA does have a way of helping, but as you've just seen, it's not incredibly accessible. We have to change this. But one of the things that I'm struck by talking a number of diaspora societies is that way that like-minded people with similar backgrounds, similar experiences, provide support. And there are networks, of course, of other groups of people as well. But fundamentally, what we're talking about here is how can we help you the most? And that is by having the rules changed. And that is one of the things that we need to invest our time in, because I'm not going to be able to change the legal system overnight. I'm not going to be able to change the GMC overnight, but I can keep plugging away at the culture in which we're working in. So, the culture that you and I work in is competitive, combative. It's driven to deliver tons and tons of care for the least amount of resource possible, and often taking shortcuts. It works in an environment of blame. And there's that situation of, well, do you know what? Just carry on, right? We know it's wrong, but let's just carry on, right? Whereas it should be collaborative and empathetic, and we should be driven by quality, not quantity. And we should want to learn from what's wrong. And at the point at which it is wrong, we should be able to say, stop, make it safe, and not be penalised for being the person that does that. Now, I've just stuck this up. I just grabbed it off some work that I've been doing with the Australians about psychological safety in business, because it's just to emphasise that this is not our NHS. Right? If you have a look at those certainly the top 10 of those, how many of you working in the NHS feel that is the environment you're in? It's not, and that is what we have to change. Part of that is us being an ally to everyone around us in our workplace. And it's not to the people who are like us, it's to those who are not like us, because people see things differently. They can see the same event differently, like the cartoon. There is more than one truth, right? And the difficulty is we spend our time arguing over whose truth is superior to someone else's. And that's the difficulty with an adversarial rather than a learning system, right? But being an ally to those without power, right? The people who need to speak up, facilitating, enabling them to speak up against those who are perceived as more powerful, especially if we are in a situation in which we could intervene. And we should speak up when we know we should, but it's difficult, right? How you do this, when you do this varies. And the answer, of course, is that we should practice and make it part of our everyday vernacular. So what are we doing about it? Well, what are we doing about it is what are you doing about it? don't accept the status quo, right? So I'm quite happy to hear the feedback and see the feedback in the chat bar. We don't accept the status quo either. There is so much more to do. That includes changing the BMA's own culture, which Chaand started, and we've tried to continue. And the fundamental way we're trying to do that is to facilitate the BMA being more present, organising locally and collectively, so that there is better workplace representation, which then puts no member, no doctor ever alone, never isolated, because there is always someone there to be with you. And as part of that, we are challenging the GMC, government, NHS, Department of Health to change and taking them on. We're taking them on one fight at a time. You will know that there's some very public spats going on at the moment, but please don't think that caring about people and making this difference that you are talking about today is not any less important. The BMA always likes me to put up a hard sell here, but really what I want to do is I want to change the culture in the workplace. And those of you that have known me for some time will know that that's a major part of what we aim to do with the remaining 19 months of this current council. So thank you very much. I will try, let me see whether I can stop sharing now. That's my run through. I hope that is useful.
Thank you very much, Phil, and I hope you'll be able to stay for the Q&A at the end of the session. And thank you also for joining us in your, I hope it's a holiday, but thank you for joining us from France. Now, I did actually overlook the fact that we did have an account of an anonymous doctor that I missed after Peter spoke. So I'm going to invite Raj Chaudhary, who has been mentioned before. Raj, please introduce yourself. But Raj, you've been highly impactful to me personally in terms of the understanding of the systemic failings in the whole GMC referral process. So thank you for that. But please go ahead, Raj. And if all speakers could be a little briefer than perhaps they were intended to, simply because we are a little behind time. Raj, over to you.
Thank you so much, Chaand. I am Raj Chaudhary. I'm a medical legal advisor, and I represent doctors. I used to be a urologist, but I left urology many, many years ago, about 24 years ago. I come across many interesting cases which demonstrate various issues that exist in the profession at the moment, and how doctors are not supported and should be better supported. So I am today going to present one case of an anonymous doctor who somehow overlaps with our team here, which is Voice of Doctors, and there's a link between their story and Voice of Doctors. So during last year's conference, there was a call for help from a doctor, a British qualified non-white doctor. The doctor was halfway through a medical practitioners tribunal hearing. Due to interim conditions that had been made, it was impossible for them to get paid employment. They had been placed under direct supervision, which is in effect amounts to suspension, although they're not suspended, but impossible to find any paid employment. The doctor was in severe financial difficulty. So here was a request for help, cry for help almost. So over several conversations, the doctor revealed mental illness due to the stress suffered in going through previous 6 years of involvement with the GMC. This had caused family relations to break down, and the doctor being left completely on their own, unsupported. During the part of the tribunal hearing that had already been completed, the doctor had had panic attacks, but felt that the legal team who was supporting them and had been appointed by a defense union had very little sympathy. And this had resulted in despair. Suffering from mental illness, lacking family support, living with no money, on overdrafts, suffering from panic attacks, it seemed unlikely that the doctor would be able to go through the remaining reconvened tribunal hearing and survive. Gradually, it became evident that the doctor had been unfairly removed from training and then left unemployed. The postgraduate deanery had not undertaken an assessment for issues affecting their learning or for neurodiversity. Now, these are standard things nowadays, but that hadn't happened. The trade union who was representing the doctor in the training issues and in employment issues had not challenged pretty important breaches of contractual rights. And that resulted in the doctor being removed from training. The defense union, medical defense union, had chosen not to get involved in training issues. The GMC had chosen to label incidents which were manifestations of the health issues of the doctor as misconduct and decided to allege dishonesty. And that was the hearing which was taking place at the time and was halfway through. The defense union had not understood the health issues and had altogether failed to address them. So there was no recognition of the health issues. So there had been no attempt to seek reasonable adjustments during the medical practitioners tribunal hearing. And that was resulting in enormous anxiety and panic attacks and dare I say, risk of suicide. The defense union had basically taken a hands-off approach, limiting itself to appointing lawyers to represent the doctor in the hearing. And the lawyers had basically, lawyers are lawyers, they are not medics. But there was absolutely no involvement of the medical expertise of the defense union in that hearing, and the doctor was basically left on their own. The result was a doctor who had begun with issues which, if they had been properly supported, the issues were remediable and would have resulted in the doctor progressing in their career with some support, but they would have become very useful members of a medical fraternity, fully functioning. But here we were coming across a doctor who had been impoverished, severely ill, feeling hopeless, and in danger of taking their own life, going through the medical practitioners tribunal. As a result of the call to Voice of Doctors, we decided to provide voluntary support from the side, and we did what we could, when really that should not have been necessary if there had been proper representation, if they had there was and that's something to do with the way that the support for doctors is structured. So I'll come to that later on, perhaps during the Q&A. That and as Chaand alluded to in the beginning, that often doctors fall through the cracks between the trade union and defense union remits, and they don't get supported. And in any case, the support is not properly designed to cater for outliers, and this doctor clearly was an outlier. They had some issues with their health to begin with. So there was no proper support from the defense union, no proper support from the trade union, and the GMC had taken what it normally does, a very adversarial approach, labeling what should have been regarded as health issues and manifestations of ill health as examples of misconduct, which was then resulting in allegations of dishonesty. With a lot of support and preparation, which again should have come from the defense union, but with a lot of support, the doctor was somehow able to get through the reconvened medical practitioners tribunal and survived, literally and metaphorically. So still alive and still potentially has a chance to remain in the medical profession. I would conclude this by saying that doctors deserve better support and compassion from their employers and from the GMC, but they also need a defense structure which is fit for purpose. Thank you.
Thank you very much, Raj. And we are running late, but I will take the final. Thank you very much, Raj. There will be a chance for questions and answers at the end for Raj as well. So the final session before we have a short break is entitled Pushing for Change to Address Professional Distress. And I want to invite Stuart Lythgoe, I hope I pronounced your name correctly, Director of Operations at HCSA, to narrate how they're pushing for change on protecting life and livelihood of doctors, and how they're campaigning for reducing inappropriate investigations. Over to you, Stuart.
Thank you, Chand. Is my display visible to the audience?
Yeah. Yep.
Yeah. Okay, thanks very much. I'm conscious of the time, and I will move more swiftly than planned. So I must start by saying that the Voice of Doctors is a hugely important initiative, and this conference likewise. And what we have heard has been sort of compelling and reinforces, in fact, the experience that I have had since joining HCSA 5 years ago. HCSA applauds Viji for her dedication to improve the conditions of the profession and preserving the memory of her husband. Naturally, we endorse the doctor's charter, and there should not be, and I'm going to just sort of, these are the topics. Introduction, which I'm going to do very briefly, partly, attrition and its consequences, trade unions and medical defence organisations, an indictment of the GMC and HCSA action in support of that, and then the HCSA playbook by reference, and concluding with what I'm describing as the HCSA counterattack. So moving on to that, the Doctor's Charter, it should not be objected to at all by the NHS. If one looks at Baroness Dido Harding's letter, learning the lessons to improve people practices, which was the product or resulted after the inquiry into the suicide by self-immolation of the nurse Amin Abdullah, that letter sets out in more detail factors that and considerations and obligations on the NHS, and this is an unredacted letter that should be wholly supportive of the Charter. In terms of me, I am a barrister, a retired one now, but I was in private practice for 6 years and served as an army lawyer for 23 years. So I come from an establishment background, but I can tell you that I'm appalled by what I've seen of the way in which NHS doctors and, from I've heard about it, nurses are treated. And I think that's partly due to a failure of having employed lawyers. Now, I know there's been quite a lot of criticism of lawyers, I understand that, but in actual fact, lawyers that are employed and dedicated to the best interests of the tradition of their service, whether it's the army or the NHS, can contribute massively and in a very positive way. Moving on, the attrition. Well, there's already been reference to protected nature, GMC referrals and internal disciplinary processes, so I'm not going to go on that, but those delays sap both personal and professional confidence. There are also attempts often by employers to divide and rule doctors, setting the conditions to isolate doctors so they don't have support, and setting the conditions for a dismissal by some other substantial means, which is a means of dismissing someone with a lower hurdle than normally applied. And then I advise people, if they haven't seen it already, to look at the post-disclosure survival strategies document, which sets out the severity and breadth of detriment suffered, and how it shows how broadly that can be, much more broadly, unfortunately, than Viji's husband and Ataullah. There's already been reference to the differences between the roles of trade unions, principally concerned with conduct issues internally and employment law issues, and also the medical defence organisations, which are concerned with capability issues and professional ethics. However, an important point to bear in mind is that when an issue, a conduct issue, moves from the internal process to the GMC process, that is when it's transferred effectively the conduct to the medical defence organisation. Therefore, it's absolutely critical that the trade unions and the medical defence organisations cooperate, not to ensure that there's a seamlessness to the way in which they operate. They deconflict the defence of doctors. They plan to rebut the allegations that are made with a view to not just the internal proceedings, but the risk of a referral, an internal and a GMC process. So that's a critical part of what HCSA does. Likewise, engagement with GNC employment liaison advisors. There's not time to talk about them. They are a cause of deep concern to HCSA, their role and the interaction they have with the internal processes of managing referrals. And then, of course, use of subject access requests to find out what is going on in situations where doctors are often simply unaware of what is the actions that are being taken against them. Moving on to the GMC indictment. Well, reference to delay already. We know justice delayed is justice denied. It was set out in Magna Carta in 1215. That applied to the legal system. It applies just as much to the processes of the GMC and the internal disciplinary processes. Years in both sets of processes are not uncommon. We have the inadequate responses of the GMC, wholly inadequate to vexatious and malicious referrals in situations where it is able to take action for managerial and non-managerial roles who adopt, and it simply almost always refuses to do so. The GMC rides as if it is almost untouchable. There's been reference to the Interim Orders Tribunal. There is a process, an entitlement to appeal to the High Court. Of course, that's costly, uncertain. And although there is a process of seeking an early review, that's earlier than the 6 months, that is at the discretion of the MPTS. That's simply not sufficient. And we need to have a right of early review or some other independent appeal process as of right. Moving on to that, then it seems as if the GMC is untouchable. That's been addressed in the Health and Social Care Committee. Really, the only legal oversight for the GMC is the Privy Council. Now that is unsatisfactory in itself, but I can tell you that the HCSA is building a case that will, in due course, we hope, have sufficient substance and evidence to support it, to put a case to the Privy Council. But we're at early days, and any information or cases that you have that you believe would assist in that, please inform us. And in terms of criticism, back in 2018, the HCSA called for said that Charlie Massey's position was untenable as a result of his intervention in the Bao Garba case. He's still not resigned, as we know. Moving on. If you haven't read it, please read the HCSA playbook. It's largely the credit for its creation is Sasha, who's on this call. Essentially, it's called a playbook because it sets out, on the basis of evidence and experience of HCSA national officers locally, what is a disturbing pattern for the way in which doctors in hospitals are treated. And then moving on to the counterattack, as I've called it, we're exploring the possibilities of using the criminal law. Now, this naturally would be the police reports being made to the police with respect to the way in which medical managers and non-medical managers treat doctors. And the reason for that, there's possibility of three possible lines. One is that the pattern of the detriment that we've seen that's referred to and summarized in the playbook is across the UK. And it sets a real concern that it amounts to circumstantial evidence of coordination by aggressive managers, coordination to a degree that might amount to conspiracy to harass. In addition, we have, in individual cases, harassment as a criminal offence itself, and in situations where records have been changed, there's the possibility of prosecution for misfeasance in public office, and the police are investigating such an allegation, the last mentioned one, at a trust in England now. In terms of the HCSA support to members, we've instituted what we refer to as a wraparound whistleblower protection. It involves, in summary, educating members about how innocuous a complaint may be and how a simple applying by reference to a safety concern using internal processes might result in detriment being visited upon them. We say also not only to realise what a complaint is, and a legitimate complaint is a protected disclosure, but we advise members to come to us on a preemptive basis to get advice before making the complaint and to set the conditions best for making such a complaint or raising a concern about safety and deciding where it should go. A part of that setting the conditions process is confirming alliances with colleagues with a view to minimising the risk of the person who raises a safety issue, which we've heard about a number of times today, being isolated. And that is very common. Regrettably, that people find that many of their colleagues that they think will support them run for the hills. And there's a real problem with that. Another aspect is a strict adherence to MHPS and with a threat of a breach of contract claims. And there is an interesting option in Jersey, in the Channel Islands, that would be of value, I believe, in the UK, where it's possible to bring a claim before the Jersey Employment Tribunal for non-compliance with disciplinary policy. And if that claim is successful, an order is made against the employer. It's been used in the past, and although an order may not sound a very weighty outcome, it's a public one. It's one that embarrasses employers and can well set, and I've seen it used effectively, the conditions for a change. And then the last point that I wish to mention is cooperation with patient advocacy groups, the National Guardian's Office, and using, to extent and in appropriate cases, practitioner performance advice as a part of NHS resolutions. Thank you very much for listening to me.
Thank you very much, Stuart. And just to thank you very much. Just to say that we're now going to take a 10-minute break. But Stuart, you will be, I hope, joining us for the panel Q&A. Is that right? In about 10 minutes?
It is.
Okay. So look, everyone, you've been very good at, staying for this time. Please, stretch your legs, grab a cup of tea, and let's meet in 10 minutes at 5 to 5, 4:55. We will reconvene. Thank you very much.
Hi, Viji.
It's Ifat, yeah.
Hi, I just wondered if I could just share the questions that I've picked up.
Hi, if everyone is on the call, you see.
Yeah, I know. I just how do you want me to share them with you? I've done it in a Word document. I just don't know the way.
You can you send them to me by WhatsApp?
WhatsApp, or shall I direct mess? I don't know
Email,
how to
yeah.
okay. Okay, I've got.
Or send me an email, whatever.
Okay, I will send it to.
Send it to me and I will sort it out. Yeah.
Yeah, Viji's got everyone's contact. I'll send it to you, Viji. All right, bye. Hi, Sasha.
basically ticking the wrong. He eventually, unfortunately, had something like a heart attack in one of his MPTS hearings. And he was unable to attend the last hearing, which I did attend with my banners. And I'm pleased to say his case finally collapsed at that stage, and he was allowed to get on with his life. And so out of that, I had a little bit of experience of dealing with numerous similar cases. For everyone's information, I was a journalist before I entered medicine as a mature student, and I am still very interested in this area of helping doctors in distress. Thank you.
Thank you. Thank you, Samantha. And also for all the work you have been doing and continue to do. And we've also got Stuart on the panel. I think I've mentioned everyone who is on the panel. Okay, so over to Ifat and Sasha. Which of you want to ask the first question?
Shall we do one each, Sasha?
Yes, if that's it.
Yeah. So the first question is, I put at the top because that's a difficult question. Why should you get easy questions? Thank you for the question. It's PB. It's a challenge and it's a really important question. It says, I have no experience of the GMC, but is there a way to campaign for those being investigated to be provided with payment for lawyers, as why there should be such an unequal situation when GMC trusts use hugely expensive lawyers and the doctor may be unrepresented? The difficult one.
So I'll give everyone a chance to speak because I think everyone's got something to say on this. Let's actually start with, I'll start with Stuart.
Yes, I think the answer to that really is join a medical defence organisation before a problem starts, and they should provide you with the support, or a reputable insurance company that provides the same level. I can't see that there's any way at all that public funding is going to be made available for this, because otherwise there'll probably be a call for public funding to support other professions in disciplinary processes.
I'll ask Phil next. Phil, from the BMA perspective. Sorry, we can't hear you, Phil.
On mute.
You don't look as if you're on mute, but we can't hear you. Just try them. Okay, I'll take someone else, but Phil, maybe it's just a case of trying to reset the microphone. Did you want to come in? Or I can't hear you either. Is it me? Maybe is it my speakers on?
You're fine.
Oh, I can.
You're fine.
For Stuart, but I don't want to stop the other panel speaking. I'll ask.
Okay. Okay, I've got Raj. Raj, any thoughts? Because Raj, you will be very aware of doctors who have not got legal representation, who have not had legal representation. So
yes,
maybe you could
I think I take Stuart's point on board that everyone should have defense organization membership to be represented, but it's a fact of life that many doctors appear in the medical practitioners tribunal hearings unrepresented, and they should be supported. They should be supported at present. I think that the GMC should provide basic representation itself if a doctor is unrepresented. They spend massive amounts of money in bringing representation for their cases to be prosecuted. If a doctor is unrepresented, at least they should have some basic representation. I think there's a massive problem. The GMC spends a huge amount of money in hiring lawyers, and the way that the hearings are conducted are terribly adversarial. I have used the term the doctor's registration becomes a trophy for the GMC's barrister, and their success is counted on how severely they get the doctors punished. So it's such an adverse environment that it must fall on the GMC's shoulder that these doctors are not left helpless in that situation. So while there is no mechanism at present, but I feel that there should be parity of representation, and it should be the GMC's responsibility eventually, if somebody is not represented, to provide them with some representation.
Thanks, Raj. And let's not forget that the Crown Prosecution Service gives legal aid to people there. The government is, or the state is prosecuting. So it is a basic right, I believe, as you've said, Raj. Phil, do you want to see if your microphone works now? Oh, we can't hear you. You're welcome to reboot or whatever. I'll be happy to bring you back in whenever. We can't hear you. Okay, I'll leave you to see if there's anything else you can do. Samantha, any thoughts on this question?
Yeah, I mean, if only, yes, it should be like the normal criminal prosecution process where if you've got a defendant who's got no one, they can get through the public purse a public defender. And unfortunately, what you end up with is something very similar to poor Dr. Odoye, who was in the end taken to the High Court and on the most tiny of pretexts, saddled with a £26,000 bill. Now, the last thing I heard was his solicitor was challenging that in view of the collapse of his case. And I'm not quite sure whether that's proceeded or worked out or whatever. But the costs can be absolutely astronomical, way down on doctors who actually aren't able to work because they're in a state of suspension or having to follow an interim practice order where their working practices are severely curtailed. So all the weight is on this poor doctor who's already got the stress of an investigation going on. Little wonder that my poor chap ended up in intensive care at Manchester Royal Infirmary. So yeah, that has to be looked at in a sense, in that the GMC has to have some sort of responsibility to ensure parity of arms. Agree.
Thank you. Right. Before I go on to the next question, I'll give Phil one more go.
Is that got any sound?
Perfect. Whatever you've done has worked. We can hear you, Phil.
Right. Okay. I mean, it's difficult, isn't it? Because the trade unions are not insurance. You know, they're not offering an insurance policy. Therefore, you know, it's about what's right and wrong. There's not a kind of automatic representation. So it's how do we get to a point where that automatic representation is present? You know, and I think that's one of those things about having a collective thought about how to make sure that no doctor goes into this unrepresented, because clearly the odds are stacked against them when they're not, you know, represented. So I think part of the most important thing that the unions can do is to work with the MDOs to make sure that no one slips through the cracks, right? And that is something we could do better at.
Thank you, Phil. I think I've asked everyone in the panel. So the next question.
Okay, so the next question was from Prem Jayapal. And in fact, there was a similar further question that came in as well. So essentially, Prem's question was, is there an alternative to current unions when it comes to representation, as the BMA often represents the Trust LNC and therefore don't provide independent help? So it's a kind of a conflict of interest type of a question.
I will actually ask Phil to come in first, only because I think I'm not sure it would be correct to say that the BMA represents trusts. That's not what the BMA is. BMA represents doctors. But maybe, Phil, you may want to have the first right of reply.
Yeah. So you know, I mean, there is a mechanism whereby, you know, doctors from more than one part of any particular investigation can be supported by the BMA and work completely separately. So we don't support the trust. But the perception that we do not support people well enough in the workplace is something that we've listened to, and we are restructuring the BMA to take into account. So, for example, we have brought in what used to be the first point of contact was, a telephone service. That's now come back in-house, which will boost our ability to look after people in the workplace. Are there other trade unions? Yes, you've got the HCSA, and even BAPIO is trying to go into that space of helping people with an issue in the workplace, as it happens.
I'll just go around. I'll ask Raj next.
So I didn't get the question very well, but I think that it was to do with BMA providing support on more than one doctor in a single case.
Sasha, do you want to just repeat the question?
Yeah. So essentially the question's about alternatives to the BMA, basically, fundamentally, because it may be that the BMA, there may be a conflict of interest with the BMA. So therefore, are there other unions, are there other trade unions and other methods of being represented?
Okay, indeed, yes. There are two doctors' trade unions. BMA is, of course, the better recognized one, but there is HCSA as well. And Stuart Lythgoe and yourself, Sasha, are both from HCSA. So there is an alternative to BMA. But if you are a BMA member and you are involved in a case where you are being where the other party is also being represented by BMA, then I think that BMA tries to maintain distance between the two representatives, and they tend to work separately. But perhaps to maintain that clear distinction between the two representatives, it may be useful that the two trade unions collaborate between themselves, and they from time to time hand over representation of one of their members to the other one. That's one suggestion I can give.
Right, okay. Stuart, I know the question mentioned the BMA, but presumably the question applies equally to any trade union, if I understand that, if I understand the question correctly.
Well, I heard the question say, is there an alternative to current trade unions, and then set off a reason for it. I think a couple of points to make. One is that I think it's a mistake to sort of tar all other unions with a criticism that's applicable to one, and that would be you might get a criticism in HCSA, and it would be inappropriate to label another trade union or the work that Raj does, and Raj does some excellent work as well. Let's not forget that. But so that's the first thing I'd say to that. The second one is, so far as I'm focusing on HCSA, we have local national officers who are committed to the needs of members locally, and they know the best way to support them. There will always be situations where a trade union or an organisation that members belong to, there's another person who's on the other side, for instance, a bullying and harassment type allegation or something like that. And I would imagine that the BMA does what we do, and that we completely separate the representation of those two members in that situation. So there's different national officers that are representing them, number one. Number two, each of those national officers is excluded from digital access or to be able to view the records of the case in respect of the other member. And we put other procedures in place. They each report directly to me, and I make sure there's a complete separation of the management of those two cases. So that situation happens in all sorts of organisations. It can happen sometimes elsewhere. It's about managing it fairly and making sure that the appropriate rules are maintained. And I'm confident that if there's a will to do that, there can. And therefore, I don't believe that one needs an alternative to current trade unions. It's about trade unions doing what they should do, and have, if they've been working properly, should have been doing for decades and more. Thank you.
And finally, Samantha.
It's funny, the very words I was going to say have just popped into the chat, and I don't wish to embarrass Raj Chaudhary, but his words are join the DDPU. Now, Raj is very modest about this. He actually runs the DDPU, which is that organization that can bounce between the employment side of things and the medical defense side of things. They will hold you in both hands, as it were. And I would say to everyone on this call, if you aren't already a member, please join, because Raj's service is pretty exceptional. As to the issue of conflict of interest, yes, it can be very revealing who is on whose side when your back is against the wall and your union is meant to be standing with you. In my experience, there's been quite a lot of compromise where I'm not really prepared to compromise. And I've, in the past, really been the sort of arbiter of my own fate, in that I've said, thank you very much for your advice, and gone and done it pretty much my way. So I had options along those lines that were slightly off the beaten track. As I say, I was a journalist, and I did use my journalism contacts to fight some of my battles along the professional route I've taken. That's not a route that's available to many people, but to be brutally frank, I have used it for some of the protests I've fronted in my time, including Dr. Odoye. So, this is a difficult area. This is an area, I think, in which we're not really very well served, and that idea of trying to please both sides of the argument can be frustrating. And my advice is step out and get good advice, hopefully somewhere like the DDPU.
Thank you. And Peter, you're not on the list, but I think it would be remiss not to seek your input as well, Peter. Maybe that was an omission. I'm sorry if that was, but your thoughts on what you've heard so far in the previous question and this one.
There's nothing there that I would disagree with, quite honestly.
Right.
So no, very supportive of the views so far.
Thank you, Peter. Okay, we'll go to the next question. Whilst we're waiting for the next question, just to say that Roger Klein, who many of you will know has been done a lot of work on race equality, did show earlier this year that in fact there's no specific trade union that's doing everything right, and it was a major recommendation that all trade unions need to focus on this area better. And I think each of you, I mean, Phil and Stuart, have been very open to say so, and I think it's important that so it's not individual. You'll find similar criticism or similar disquiet if you had the nursing profession here and so forth, which is in the meetings I've been to. So I think there is a collective need to really raise the whole issues around workplace unfairness.
Ready?
Is the question ready?
Yes, sorry, I just had my mute on. So this is from Prem. The question is, what is the difference between MPTS inquiry and MHPS inquiry? And I think for those who are non-familiar with this, it'd be nice if somebody could answer that.
Yeah, I think a couple of us did respond, but I'll just ask Raj to just clarify.
MHPS stands for Maintaining High Professional Standards in Modern NHS. This is a framework which guides investigations within NHS trusts. So this is an employer's investigation, and MHPS is limited to employment. Medical Practitioners Tribunal service is it's the service which hears cases brought by the GMC. So although they sound similar, they're quite discrete. Medical Practitioner Tribunal Service runs the Medical Practitioner Tribunals, where the GMC presents its cases. So the fitness to practice hearings are now conducted in Medical Practitioners Tribunal. I hope that clarifies.
Thank you, Raj. The only what I would add is that I've come across, and I'm sure all of you have come across many cases where a trust will inflict double jeopardy. So they'll actually refer to the GMC and at the same time actually conduct an internal MHPS disciplinary hearing. Now, for that individual doctor concerned, this can be just, it must be just beyond harrowing that in fact you're being attacked from both fronts. So just to say they are different, but they actually are often additive at the same time.
Can I just add to that, Chaand, if you don't mind? Yes, of course. This is something very important, what Chaand has said. Issues which are raised in MHPS investigations often end up landing before the Medical Practitioners Tribunal. So there is a continuity between what happens in employment and what happens in the GMC. And an ideal defense organization would bear that in mind right from the outset. So when a complaint is raised, the defense organization would be thinking of how it's going to eventually pan out before the Medical Practitioners Tribunal service or Medical Practitioner Tribunal. And this is why it's not a good idea to have two defense organizations separate. That is, the trade unions providing one part of representation and the defense union providing another part of representation. I think a continuity between the two, a single defense organization, right, taking the issues right across would be much better than having these two separate defenses.
Thank you. And I think we may have time for just one more question, or depends how long the questions will be. Yes.
Well, I'll go down to the next question. We do have a lot of questions, so what we might do is circulate the questions amongst the panel members for some form of written response that we might be able to share in some way, just so that people don't feel like their questions haven't been answered. But the next question was from, and I apologize if I'm not pronouncing your name correctly, but Sachin. And the question is, does the Protection Society not help with asking the Trust and the GMC about false allegations? So I think this is a question about do the medical defence organisations and trade unions not actually inquire and really tease out issues regarding false allegations rather than just simply accepting the allegations? And forgive me if I've misinterpreted the question, but I think that's what it is.
Thank you. For this one, the people who probably have got greatest knowledge about how this process works will be Raj and Stuart. So maybe if you just give your thoughts on whether there is efforts made at that higher level regarding malicious or vexatious complaints.
Well, perhaps I'll just step in and say yes.
Yeah, sure, Stuart.
Definitely there are. I've done it personally myself, where I've represented people through a process of escalating internally through the trust up to the chair, and if that's not been unsatisfactory, and there's been two occasions when it wasn't, I've then escalated the case to both NHS England and also the GMC. And NHS England, unfortunately, it was although I wrote to the previous CEO, it ended up being pushed back down to a sort of relatively lowly department that had a brief conversation with the trust and got some sort of assurance and then decided to take no further action. So that was a sort of toothless tiger response to a concern about from a regulator. So far as the GMC was concerned, I escalated up to Charlie Massey, but going up there, the responses that I received, I didn't receive anything from Charlie Massey himself, but the response that I received was, well, when I raised the issue about misrepresentations to an employment liaison advisor, gross significant misrepresentations about a case leading to advice that the doctor be suspended. Yeah. When I raised that, the GMC said, well, we don't make inquiries into trusts, into employers. And I said, but surely you're concerned about the quality of the information that you're given. And they didn't appear to be, because nothing came of it. So frankly, we do intervene. I'm sure that the BMA, I'm sure that Braj does. as well. It's gaining sufficient traction, and that's why I think the agreed views of those here is that the present system is not working, and we need to challenge the GMC, and it has to be done at a high level, and it's almost certainly going to have to involve politicians.
Thank you, Stuart. Thank you, Stuart. Raj?
It is an uphill battle for defense unions to take out, to pursue complaints against people who are putting in malicious complaints. Like Stuart, I have actually reported someone to the GMC as well, and I actually handed it over to the previous chairman of the GMC, somebody who is well known and who used to be a pediatrician in the Royal College of Pediatrics president. But that complaint, very serious complaint with lots of evidence of discriminatory behavior, that went nowhere. And I received a reply that the person who had done the discriminatory act was in fact whistleblowing. So she was protected. You keep trying to report these things and the GMC doesn't listen to you. Of course, the trust won't listen to you. You have to just hear Peter's experience and how the trust treated him. There is corruption. There's just corruption there, plain corruption. You have an uphill battle. Peter has raised his hand, so I must give way.
Thank you.
Sorry, I didn't mean to interrupt you there, Raj. I was just going to say I totally agreed with all of that. And yeah, that was exactly my experiences, is this remarkable indifference and lack of interest in finding out how these sort of things happen and how evidence suddenly appears in the record. And it doesn't just apply to the GMC, because they went off on a wild goose chase for 2.5 years, but the CQC, NHS England, they all just seem to have this complete lack of interest in how these sort of allegations come about and how they end up being turned into the sort of witch hunt.
Thank you. I'm going to ask Viji. Viji, do you think we have time for another question, or should I wind up now? What would you like me to do?
We will take one more question for 2 minutes, 2 to 3 minutes.
Right. Okay. Over to either, Ifat.
There are a couple of questions that are similar, so I'll just ask one of them. The BMA lead on a campaign, or the unions lead on a campaign, that those who fund the GMC and pay for it have a say in the members of the council or board, similar to the BMA. It's not a union, or we pay and finance the GMC. Please may the funders have a democratic choosing of that it represents doctors.
Well, I'll take Phil first for that. Phil, go you first.
Of course, that is how it was in the old days. But of course, it's not been like that for a while now. It is really difficult to know who runs the GMC. It does not seem to be accountable in the same way that the BMA is to its council members. The relationship between its executive team and its council does not seem that transparent to us at all. Now, that does not stop us needing to campaign. And what I thought was really interesting was Stuart is completely right. This needs a political solution to this, because it is just unacceptable that the GMC and NHS can just fob off people with genuine concerns about process and transparency, and it's the sinister undertone of it which has to stop, and which needs us as a group to stand up and campaign and say this can't continue.
Okay, thank you. 1 second. All right, thanks, Phil. Does anyone else want? I'm going to just ask any of the other panelists, including Peter, to raise their hand if they want to say anything about that question. No. Okay. Is that the last question, Ifat, or did you say there was another?
Could I request Chaand to comment on this question as well, with your experience of
Sure. Okay.
medical
Sure.
settings?
Sure. So I actually think that the bigger issue isn't about who sits on the GMC Council, although, you know, I think it is very important. I actually think that the structural processes and the way in which the GMC behaves needs dramatic reform. And I think if you think of all the questions that have been asked and the answers that have been given, in fact, even the way in which the GMC decides to take on a case, the way in which it accepts the rather often biased case building referral, that requires a change in the way the BMA should behave. They need to be actually talking to the complainant. They need to get the other side of the story. It isn't done like that. If you look at their decision, as I said earlier, to even investigate, that should be externally scrutinized. It shouldn't be left to them. When you actually look at the way we heard from others around the way they investigate, or everything I said at the beginning, it's investigated in, you know, they have the upper hand in the information they can get and the way the barrister-led criminal type of process. And then you get a hearing where the doctor is at the mercy of the barrister for the GMC winning a trophy, as you put it, Raj. So I think all of that has to be reformed. And I think also the civil standard of duty is far too low when you're looking at people's livelihoods. I came across a case very recently where it was a word between a doctor and a patient, no witnesses, just two people. They believed the patient. There was no one else. And you'll be aware of this case, Raj. No one else, no witnesses. Now, just believing one side rather than the other, and it was an ethnic minority doctor, that doctor has been struck off the medical register. You know, that's what needs to be reformed, in my view. So anyhow, so thank you for asking me, Raj. Should I, Viji, now move on to the summary and close the meeting? Yeah, okay.
Yes, please. Yes.
So, okay. So first of all, and I really mean this in a heartfelt way, I want to thank all of you who've attended today. You know, it's a Sunday, it's prime family time or leisure time, and you've found time to be here. And what that tells you and all of us is that this issue matters and that you care about this issue and you care about it for the people that you represent and for the good of the medical profession. And I thank you for caring. I think it's also important to say that we can all play our part, all of us. If you're a clinical director, you're here, a medical director, you hold a position of leadership, right down to if you're someone on the ground. We all can play our part, because just come back to that statistic, 98% of referrals to the GMC for doctors found not guilty. So we can do a lot, and we must do a lot to prevent people even getting escalated to the point of a referral. And we can do that. We can provide advocacy. There's a role for trade unions. There's a role for all of us to do that. I also want to thank, and again, I'm sure all of you would join me in this, to Sasha, to Ifat, and to Peter, because they shared their honest personal accounts and their experiences. That's being very brave of you and being so open. And I want to just thank you for sharing your personal stories, because those personal stories just highlight the reality that colleagues, doctors are facing. So thank you all. I want to make a plug, actually, for Ifat's film. And in fact, if there's a way of putting it in the chat, the link, please do so. Because if you haven't seen her film, Multiple Jeopardy, honestly, it just encapsulates so movingly the issues around this and the circumstances that led, sadly, tragically, to Dr. Suresh taking his own life. But those issues apply much more widely, and they are a compelling argument for why the system has to change. So please do put that link, Ifat. And finally, of course, a huge thanks to Viji for, as we've all said, channeling grief in this laudable way to create good for the profession in the future, and alleviate the distress and pain that people are experiencing and have experienced, as you heard today. So on that note, I'm actually going to ask Viji to finish and have the last word or close the meeting, talking about the survey and the doctor's charter more specifically, and And so I will hand over to Viji. Now, if you've got a hand showing, is that right? Did you want to say something? Okay, so I'll close here and pass it on to Ifat, and thereafter Viji will have the final words. Ifat, over to you.
Just a quick question, Viji, just people might want the chat. Just thought I'd ask you about that. That's all.
Okay. So I can't, I find words to thank you all for being here on a Sunday. And of course, all the panel members are being pinned here, including Sasha. Without you all, we wouldn't have done this. So every one of you in this panel who are pinned here in terms of Ifat, Sasha, Phil, Stuart, Samantha, Chaand, and Pete, Raj, all of you have done a huge part to make this a kind of a knowledgeable session for everyone. And it will be useful for someone who is going through this kind of any situations of professional distress. So throughout, what we wanted here is to create awareness and also to work on the doctor's charter. And how do we do it? It can be done mainly through the doctor's voice. It is mainly through all of your voice we can bring in the change. And it does matters. It clearly matters. The outcome of the survey that we have received is an absolutely amazing result. And if we can present this survey results to bring in, and what our next step is going to be is to enhance the survey through lots of leaders. We do have many leaders within us in terms of medical directors, working in trust, working in ICBs, or lawyers, or policymakers, and we do have the biggest trade unions, BMA, as well as HCSA with us, and which is a blessing for us. And we have all the right people here who can bring in the change. And that is a big thing. We are slowly gathering the right people, and we have got a good team now, which is asset as it stands. So how do we move this forward in terms of, so I invite all of you, because there are lots of senior consultants and senior staff committee members who do audits and work with junior doctors. We are happy to give a use case for them to conduct some audits and to write some blog articles. We have the Voice of Doctors as a portal where everyone can send us your work. We can present it inside the portal as your work. It is your work. Nobody is going to own it. And it is not, I'm just a facilitator here to creating these platforms. Everyone, please do come forward to bring your audits, to show your presentations, show a small summary, one pager of work. And of course, you are all welcome to do some kind of an internal surveys, which can be presented here. It is a portal for everyone to share, knowledge share, and to work together. That is what it is. What we are building here is a community. It is a community called Voice of Doctors, and we are powerful. And even in this Sunday, we have got around approximately 100 concurrent users watching it, and around 365 people have signed up and who are coming in and out, which is a blessing. You are all giving your time, which means it's important to you all. And we are here to, in a yearly fashion, we are summarizing our work and trying to build it together and say, okay, we are here so far, and we do have plans. We do change, we do slowly, incrementally work, but we do bring in a change. And that is called the Voice of Doctors. And hope you all continue and we all work together. Thank you all, everyone.
Thank you so much, Viji. Yes, we're all clapping. Thank you. And if anyone has any further thoughts, you've got the on the chat. I think you've got the email address which you can send any thoughts to. And I'm sure, Viji, we can all be in touch for any updates, ongoing. We've got everyone's email addresses. So thank you, everyone, for coming along today. And I will now close the meeting. Thank you.
Thank you.